You know, the Live Nation antitrust trial, the case that you've been rooting for every time you've tried to buy a concert ticket and watch the total price double before you hit purchase, they're getting close to an end in federal court in Manhattan. 34 states did sue Live Nation and its ticketing arm Ticketmaster, some of the worst companies on the planet, and they accused the companies of operating an unlawful monopoly across ticketing, across concert promotion, and across venue ownership. The state's attorney called Live Nation a monopolistic bully. Live Nation's attorney called the company a fierce competitor. You, the person who just paid $180 in service fees to see someone you like, might actually get an opinion, get to say your opinion about which description is more accurate. In this case, it's been going on for weeks, and that's after the DOJ dropped their side of it. And there's internal documents that have been introduced into evidence that are extraordinary. Live Nation's own internal communications, and we've covered a lot of this before, include phrases like robbing them blind and using the velvet hammer to describe their relationship with venues and competitors. These states that kept this lawsuit alive, their argument is that Live Nation leveraged its control over major tours, over any big artist, those big blockbuster events. That way they could pressure venues into exclusive contracts with Ticketmaster. Venues that declined, they lost access to the top draw tours that kept them economically viable. That is using your market position to coerce. The states also presented experts that showed that Live Nation's dominance across every layer of live events, the venue ownership, concert promotion, primary ticketing, it was done in a way that makes meaningful competition impossible. Now, Live Nation argued that the concert industry is booming and that there's more competition than ever, and that the state's case was built on little snippets and insinuations that were taken out of context. Their attorney said that the statements cited by prosecutors were wrong, and that the company did not condone those statements. But the effect is still there. And when your defensive strategy involves distancing yourself from your own emails, that doesn't look good. The DOJ, they settled with Live Nation. They settled early at Trump's direction. And it was for a parking ticket, essentially, some behavioral commitments. Fortunately, these states, they continued past that because they think these behavioral commitments and the traffic ticket, they weren't enough. They want real relief. Structural relief in antitrust law can mean a breakup, splitting Ticketmaster off from Live Nation. It would force venue divestiture. This actually changes the market structure rather than just making the company to pinky promise to be nicer. And look, a judge is going to rule on this eventually, and the outcome will almost certainly be appealed regardless of whatever happens. But the fact that this trial is still going on after the Trump DOJ backed out of it, it matters beyond the immediate outcome, because it is the most significant test of antitrust enforcement that the live entertainment industry has ever seen. And it's a test of whether this Trump administration's early settlement ends up being the ceiling on accountability or if it's the floor. The states that kept going, they're betting that that's the floor. And every person who's ever paid an enormous convenience fee to a company that has made the experience of buying concert tickets more than deeply inconvenient, we're all rooting for a higher ceiling. Do me a favor, subscribe, share, leave me a comment. All of that matters to independent media like us.